Well, good afternoon, everyone. My name is Tara Eberline. I'm here with my colleague, Sarah Stula, and on behalf of Foulston Siefkin, we welcome you to the webinar. While we wish we were here to discuss a more positive subject, we're happy to serve as a resource for you all in these uncertain times. I plan to discuss a number of employment-related topics connected to the COVID-19 outbreak today, including the new federal leave laws that were passed just last week. In addition, several of my employment law colleagues, who you can see in the video, Don Berner, Forrest Rhodes, and Jason Lacey, will answer a number of questions during the final portion of our webinar. Our webinar is set up today to allow questions from the attendees as well. Use the chat function to submit your questions. Please note that those questions will only be seen by the panelists and not by the other attendees. Our focus today will be on those questions that we believe will be of general applicability to the audience due to the limited time frame available. I anticipate that many of you may have questions about how the new laws apply in your specific workplace. If you have an established relationship with an employment law attorney, we encourage you to contact your lawyer. If you don't, we would be happy to engage with you directly to answer those questions, and we're prepared to set up those relationships very quickly and be at your service. The same is true, of course, with respect to non-employment law related issues. Our firm is able to assist with respect to your healthcare questions or supply chain, contracting, or other issues that you may have related to the coronavirus. We'll have some information at the end of the presentation with respect to how to reach us. There's a lot to cover, so we're going to jump in. We're going to turn the videos off now so that you can focus on the slides. Here's our agenda for the day. First, we're going to discuss the two new forms of paid leave under the Families First Coronavirus Response Act. Next, we'll discuss the Kansas City stay-at-home order. Then we'll address navigating leaves of absence under the existing FMLA and FLSA rules. We'll briefly discuss OSHA and the obligation to protect our employees. We'll discuss ADA obligations with respect to employee confidentiality. We'll address severance agreements and requirements under the WARN Act when we have situations where we're needing to part ways with a large number of our employees. And then at the end of the presentation, as I mentioned, we'll have a question and answer session with the panel of our Foulston employment attorneys. Let's talk first about the new laws just passed by Congress last week under the Families First Coronavirus Response Act. This act provides two new forms of paid leave, and this leave is going to be paid or reimbursed rather by the federal government, and we'll talk about those details in a little while. The first new form of paid leave is up to 2 weeks of paid sick leave for employees who need to be isolated, who are experiencing COVID-19 illness, who are caring for others, or who can't work due to their childcare responsibilities due to COVID-19. And then the second new form of paid leave is a new category of FMLA childcare leave, also to care for a child who cannot go to school or daycare because of COVID-19. Here's a few details that are applicable to both the new employment laws. First, the effective date listed in the Families First Act for both of these new forms of FMLA is no later than April 2nd, 2020. That leaves some ambiguity, unfortunately, with respect to whether these laws have come into effect already today. The Department of Labor has been ordered to issue regulations, also no later than April 2nd, that will provide some additional detail with respect to how the laws are going to work and how they'll apply in specific workplaces. We believe that the new laws are not yet effective today, and that when those regulations become effective, it will be that day or April 2nd, whichever comes first, when the new laws will become effective. Accordingly, providing paid leave or unpaid leave for that matter to employees today is not likely to satisfy your obligations under these new paid leave provisions. Both laws expire on December 31st, 2020. Neither is intended to become a new form of paid sick leave or other form of paid leave that will be available after the COVID-19 crisis has passed. Both laws cover employers with fewer than 500 employees, and they cover all public agencies. That fewer than 500 employee rule is different, as you might notice, from the old FMLA rule, which covered employers with 50 or more employees. The Department of Labor is permitted to exempt businesses with fewer than 50 employees if complying with the law will jeopardize the viability of the business. Again, we believe the Department of Labor will explain that process in the regulations that we anticipate receiving in the next few days. It's not clear yet what the requirements will be to meet that standard, or what a small business will need to do to be able to establish that complying with the law would jeopardize their business. But keep in mind, as we mentioned before, that the laws are intended to be paid for ultimately by the federal government. And so although there'd be some short-term out-of-pocket cash expense by the employer, ultimately the cost will be borne by the federal government. Healthcare employers may elect to exclude healthcare providers and emergency responders from applicability under the law. Under the statute and the regulations that exist today, we feel certain that MDs and DOs, that doctors, will be permitted to be excluded by their employers from receiving paid leave under the healthcare laws. We're not sure yet what other categories of healthcare employees may be excluded. It'll be up to the Department of Labor to issue regulations that explain or further define what healthcare provider means in the context of these two paid leave laws. We do believe that we know, frankly, that there's been a great deal of lobbying from the healthcare industry towards Congress and towards the Department of Labor to ensure that definition is as broad as possible, so that we can ensure that healthcare providers have the workforce needed to be able to do their jobs in this time of emergency. Let's move to emergency paid sick leave. These 6 bullet points provide the 6 categories of eligibility that exist for employees to qualify for paid sick leave under this new emergency plan. Emergency paid sick leave can be provided to an employee under these first, let's talk about the first 3 first, and that is a reason that an employee needs to be gone from work due to their own illness or their own isolation order. So if an employee is subject to a local, federal, or state quarantine or isolation order, if they're advised by their doctor to self-quarantine because there are concerns about COVID-19, or if they're experiencing symptoms of COVID-19, even if they've not yet received a medical diagnosis, the employee is entitled to paid sick leave under the law. Those first 3 categories, again, are related to the employee's personal condition, and we'll talk about why that's important on the next slide. The next 2 categories are related to an employee needing to be absent from work due to a need to be caring for someone else. So number 4 there, if an employee is caring for an individual who's subject to a quarantine order or direction to self-quarantine, that employee is eligible for paid sick leave. Note that they use the word individual here rather than family member or son or daughter or some other definition of who that employee may be caring for. Accordingly, that employee could be caring for someone who may not even be related to them and still be eligible for this paid sick leave under the new federal law. The 5th bullet point there is when an employee is caring for a son or daughter if that child's school or childcare provider is unavailable due to COVID-19. Many of us have kids at home whose school has closed or whose childcare provider has closed due to the illness. And again, this is another form of eligibility for employees to use these 2 weeks of paid sick leave under the new federal law. That last bullet point there refers specifically to, it's a catch-all clause that has been included that would allow the Secretary of Health and Human Services to provide another category of eligible leave to employees that fits within the 5 up above. So at this point, we want to look at 1 through 3 as employee-focused sick leave, and numbers 4 and number 5 as sick leave required to care for other individuals. As mentioned, this form of emergency paid sick leave provides up to 2 weeks of leave if the employee needs it. For full-time employees, that's easy. We're going to provide 80 hours, and that's specified explicitly within the statute. For part-time employees, it's not as clear how many hours of leave they'll be eligible for. The statute provides that we need to average the number of hours worked for part-time employees over a 2-week period and provide that level of emergency paid sick leave. What the statute doesn't tell us is which weeks to average or how many weeks to average to determine the average number of hours for those part-time employees. We hope and anticipate that the Department of Labor will provide some additional guidance with respect to how to calculate part-time employees' eligibility for emergency paid sick leave under this law. One other note with respect to that first bullet point on the prior slide, which lists the employee is subject to a federal, state, or local quarantine or isolation order. We've received some questions about whether an employee who lives in an area that has experienced a stay-at-home order would necessarily qualify or would automatically qualify under that first bullet point. Our reading of the law, absent new direction from the Department of Labor, is that a general existing stay-at-home order is not sufficient to qualify an employee for that first form of paid sick leave. That category of paid sick leave, we believe, applies to a specific order given to a specific individual to stay home. Now let's talk about the payment amount. As I mentioned, for rationales 1 through 3, for the employee's own illness or quarantine, the employee is paid at their full regular rate. There's a cap, however, on that amount up to $511 per day and a total of $5,110 over the course of the 2 weeks. So again, if the employee is sick themselves or otherwise subject to quarantine, they can receive up to $511 per day during those 2 weeks of paid sick leave. If an employee is caring for their child or caring for another person who's ill under rationales 4, 5, or 6, then the employee is eligible for 2/3 of their regular rate, and that cap is $200 a day or $2,000 over the course of the 2-week time period. Again, if your employee makes less than the cap, then they would only be eligible for pay at their regular rate. It's up to the $511 or up to the $200 at the 2/3 rate. Employers may not require their employees to use other forms of paid sick leave before using the new federal employer-provided paid sick leave. In other words, if your employees have PTO, we cannot require them to use their PTO before becoming eligible for this paid sick leave. And as a practical matter, employers ought to consider and ought to want to give this paid sick leave first, because again, it's going to be reimbursed by the government rather than from the employer's personal bank accounts. Eligibility. All employees are eligible regardless of their length of employment. So if you have an employee who you hire on April 2nd to come work for your company and they need sick leave as of April 3rd, they are eligible for it under this new law. Finally, there's an obligation under the statute to provide a notice that we'll need to post for our employees. We used to do this at the water cooler, and that may not be the best way to do it at this point in light of many of our workforces working from home. But there will be some additional information coming from the Department of Labor with a proposed notice, and we'll need to make sure that we get that out to our employees in a way that they can receive it. All right, turning now to the new form of emergency FMLA childcare leave. Again, this is a different category of FMLA leave than has existed before. And this provides up to 12 weeks of paid leave, the last 10 of which will be paid, the first 2 of which will not be paid, under the FMLA. And this is available only for employees who cannot work or telework due to the need for leave to care for their son or daughter who's under the age of 18 if their school or daycare is closed because of COVID. We've had some questions about who's eligible under this category of leave. And again, the rules require that it only exists for employees who can't work because they need to care for their kids because their kids' school or daycare is closed. Employees under this portion of the law need to be employed by the employer for at least 30 calendar days. You'll notice that's different from the typical FMLA rules that require employees to be working for us for a full year before they're eligible for FMLA. For this portion of FMLA only, they need to just work for us for 30 days. This form of FMLA childcare leave does not provide paid FMLA leave for employees who are subject to an isolation order or quarantine order. It's just related to childcare obligations. As I mentioned, the first 10 days of this FMLA childcare leave may be provided unpaid. However, those first 10 days are likely going to match with the 2 weeks of federal paid sick leave that are available to employees who need to take time off to watch their kids. So, practically speaking, if you have an employee who needs to be off because their kids are off from school or home from daycare, they could take their first 2 weeks of paid time off under the new federal sick leave law, and then the following 10 weeks, they can be off under the new form of FMLA childcare leave. The payment amount matches the federal paid sick leave categories 4 and 5 as well. Employees are entitled to not less than 2/3 of their regular rate of pay for hours that they were otherwise normally scheduled to work, up to $200 per day, and a total of $10,000. With that, I'm going to move forward. I know there are likely to be some questions that I haven't answered yet with respect to these new 2 forms of paid leave, and we'll do our best to answer as many of those as possible towards the end of the presentation. We know you've been sending questions in through the chat, and you can continue to do that, and we'll address as many as we can at the end. Let's talk briefly about the new Kansas City area stay-at-home order. This was announced, of course, over the weekend and comes into effect at midnight tonight. The general order requires the general public to stay at home other than to perform essential activities. And it urges those individuals who are sick or high risk to stay home entirely other than to provide other than to receive medical care as necessary. The stay-at-home orders have been issued by each of the jurisdictions involved. To date, a number of the Kansas City area counties have issued their own orders, including Johnson County, Wyandotte, Leavenworth, Douglas, and many others on the Kansas side, as well as the Kansas City, Missouri area, Clay and Platte counties, St. Louis, and others on the Missouri side as well. Keep a close eye on these orders, as we anticipate that it's likely that additional counties will impose their own stay-at-home orders soon. If you look at the orders carefully, the rules are not the same exactly from county to county and city to city. So make sure that you take a look at the order that applies to the place where your business is operating and comply with the obligations that are at issue in that particular order. In the Johnson County order, childcare facilities are specifically permitted to be continued, but those childcare facilities are required to maintain a 10-to-1 ratio. Neither the children nor the childcare workers are permitted to change from group to group. We've received a number of questions about childcare. That's what the rule says at this point in Johnson County. Again, take a look more specifically at your workplace to see how it may be different depending on which county your business sits in. We've received a number of questions as well about whether particular businesses or types of businesses are deemed essential under the essential activities or essential businesses definitions. We're available to engage directly with businesses on that question, but in the interest of time, we won't be able to address specifics about that on this call. All right, so let's talk, practically speaking, about how to handle a situation when you receive a request from an employee to be gone from work because they are sick or they've been ordered to be quarantined or isolated in their home. First question needs to be, is telework an option? For our employees who can't be in the office because of a stay-at-home order or due to having kids at home or otherwise, if they are able to telework, we want to provide that option to them as our first choice. Next, if that's not an option, does the employee have PTO available? Again, look first to that federal paid sick leave, as we need to make that available first to our employees as soon as it becomes eligible, or as soon as the law becomes effective as of April 2nd. Once they've exhausted that leave, or if they're not eligible for it, then we look to PTO or other employer-provided paid time off. From there, ask whether the employee qualifies for FMLA leave under the traditional FMLA, and we'll talk about that in just a moment. Then we need to think about, is the employee salaried and exempt under the FLSA, and what do those laws, those rules require of us with respect to how we pay employees? And finally, don't forget that if you have employees who are subject to an employment contract or a collective bargaining agreement, we need to make sure and comply with the obligations that exist within those contracts. Overall, our general recommendation is consistent with what the CDC is requesting, and that is be as flexible as you can with your employees. As much as we can allow employees to be home, as much as we can allow employees who are experiencing any symptoms to be away from the workplace and away from any other people, the better off it will be. Give us just a moment here. We've got a technical glitch. We'll get that fixed. I'm going to keep moving on. Okay, let's talk about the FMLA. Under traditional FMLA, as a reminder, eligible employees may take up to 12 work weeks of unpaid leave for their own or a family member's serious health condition. Certainly, infection with COVID-19 will qualify as a serious health condition under the FMLA. Additionally, caring for an immediate family member with COVID-19 will also qualify under the traditional FMLA. For these forms of FMLA rules, for these forms of FMLA leave, the old FMLA eligibility rules are going to apply. That means our employees have to have been employed by us for 12 months. They need to have worked at least 1,250 hours in the previous year. And as an employer, we need to have 50 or more employees within the 75-mile radius to qualify for that FMLA leave. Only for the new FMLA childcare leave is the eligibility changed to that 30-day rule and the all employers with 500 employees rule. Okay, we're having a bit of a technical glitch here and we're going to get it fixed for you in just a moment. Just a moment, hang tough with us. Okay, I think we're back up and going. Thank you for your patience with us. Here we go. We're going to talk about the Fair Labor Standards Act. As a reminder, we need to make sure that we're complying with the FLSA rules with respect to how we pay our employees. First of all, for non-exempt hourly employees, we are only required to pay for actual time worked. If the employee has worked over 40 hours in a week, we need to make sure that we're paying for those overtime hours as well. This is easy if our employees are showing up to work and doing their normal duties. It gets more difficult when we have employees who are not used to teleworking, working off-site or in their homes. Please make sure that you're reminding your employees that they need to be accurately keeping track of and reporting all teleworking hours, whether those hours are during their normal shift or if they're answering questions after hours via email or otherwise. We need to make sure that we're paying those employees for all hours worked. For our exempt salaried employees, there are different rules, and that is the general rule for our exempt salaried folks is that if employees have performed any work during a given work week, we need to pay them salary for that week unless the deduction is specifically permitted. So if they work for us on Monday and we don't have any work for them Tuesday through Friday, they're still entitled to their entire work week of salary unless one of the specific deductions is included or is permitted. We are permitted to deduct from exempt salaried employees' pay for full day absences for personal reasons or illness, so long as we have some PTO existing for those employees. And we're allowed to deduct for partial day absences that are FMLA qualifying. If an employee performs no work during an entire work week, we do not need to pay salary. Of course, they may be eligible for federal paid sick leave or FMLA childcare leave under those circumstances. Couple of situations that may apply with respect to our specific COVID situations here. If we have an employee who is symptomatic and stays home, or if we have an employee who is subject to a government-ordered individual quarantine order, they've been told by the state or told by a local government that they need to go home, or if we have an employee who stays home to care for a child who can't go to school, those are reasons that we believe can fairly be viewed as absences for illness or personal reasons. And so deductions, single day deductions for employees, even exempt employees, are permissible for those categories. If, on the other hand, as an employer, we impose a quarantine rule, or the employer has closed a facility for operational reasons like supply chain or labor shortages, under those circumstances, we would not be permitted to reduce an employee's pay if that employee is non-exempt. Keep in mind, if we need to terminate an employee's employment, if we need to furlough them or end their employment due to a layoff situation, we can prorate that final week of pay. All right, let's talk for a few moments about how we protect our employees and our duty to do so under OSHA. The Occupational Safety and Health Act requires employers to provide a workplace that is free from recognized hazards that are causing or are likely to cause death or serious physical harm to its employees. OSHA has recently indicated that an employer has a duty under the Act to prevent occupational exposure to COVID-19. And that means that as employers, we have a legal duty to take feasible measures to reduce the likelihood that our employees will be exposed. One thing to keep in mind here, I know we have employers across the board from industries ranging from healthcare to education to many, many forms of businesses. And the OSHA obligations, although they exist for all employers, may look different from workplace to workplace. And that risk of exposure certainly is going to be different from workplace to workplace. One thing to keep in mind is that some forms of our workplaces, including hospitals, construction sites, and others, include a mix of both direct employees and contractors that may be on site at any given time. OSHA's rules impose duties under the OSHA multi-employer worksite rules to protect individuals, including subcontractors, that are on your facilities or in your facilities at any given time. So think not only about how we protect our employees, but also those other people who may be in and out of our businesses. We've had some questions about workers' compensation coverage, and frankly, we think the likelihood of COVID-19 being qualified as a workers' compensation covered occupational disease largely depends on the type of place of employment that's involved. The employee who makes the work comp claim would have an obligation to be able to establish that he or she obtained the disease due to work or at the workplace for it to be a work comp covered claim. And from the occupational disease standpoint, the Kansas statutes explain that it could be covered as a work comp covered injury if there's a particular hazard of the employee getting the disease that distinguishes their employment at this place of employment from other occupations. Healthcare is certainly the most obvious in this instance. We think outside of the healthcare context, it's unlikely that workers' compensation claims would qualify if someone were to contract the disease, but it's possible. So again, another reason why we want to be cautious and make sure that we're taking feasible measures to reduce the likelihood of spread within the workplace. Healthcare organizations in particular, it's just absolutely imperative that you're following the CDC guidance and watching the CDC website daily for updates with respect to their recommendations on how to keep our healthcare facilities safe. Screening processes. One of the things we can do to keep our workplaces safe when we have our doors open is to screen employees for their possible exposure to COVID-19. When it is permissible under the rules right now to be asking employees about their possible exposure, their recent travel, particularly their travel to the hotspots that the CDC has identified, and whether they're experiencing any symptoms of the virus. We are permitted, and we encourage you to require your employees to self-report symptoms that are consistent with COVID-19 and to immediately send home any employees who report or show signs of the illness. Some workplaces are taking an additional step of taking temperatures of employees or otherwise monitoring for symptoms themselves, and just ensure that you're following the CDC guidelines and directions with respect to how to do that and whether it's permissible. If you have an employee who tests positive or is presumed positive, we do believe that it's appropriate and recommended that you notify coworkers that they have been exposed to someone who has tested positive for the disease. Importantly, though, do not disclose the identity of that affected individual. The Americans with Disabilities Act ensures the confidentiality of that information for the employee who discloses it to us. So although we're going to share with coworkers that there has been a positive case and that they may have been exposed to such positive case, it is important that we not identify the specific individual who has tested positive. The CDC has recommendations out with respect to how to allow employees to discontinue isolation and when to allow them to return to the workplace. Under CDC guidelines, employees who have symptoms but have not been tested should remain isolated until they have had no fever for at least 72 hours with no fever-reducing medication. Their other symptoms need to have improved, and at least 7 days should have passed since their symptoms first appeared. Those employees who test positive are permitted to discontinue isolation when they have no fever, their symptoms have improved, and they've had 2 negative tests in a row, 24 hours apart. As we know, there are not a lot of tests to go around right now, and so even those folks who have had a positive test may not be able to receive 2 additional tests to confirm that they are no longer positive. In that case, certainly wait the recommended additional time to ensure that that employee is no longer contagious. OSHA has specific rules with respect to personal protective equipment. The OSHA rules for PPE do apply to all workplaces, but again, this is going to look different depending on the kind of workplace that is involved. In all instances, however, if we're going to provide personal protective equipment to employees, the employer needs to assess the workplace hazard, in this case, assess the risk of the virus being spread throughout the workplace, provide the appropriate personal protective equipment at no cost to employees, and we have an obligation to train employees on how to properly use that personal protective equipment. One instance where this pops up is with respect to masks. And it's important to understand that there's a difference between a surgical mask and a respirator. Surgical masks only protect against fluid splatter, against a sneeze, of the liquid from the sneeze entering the mouth of the other person. A respirator is different because it protects against also airborne contaminants in addition to just that fluid splatter. The OSHA rules are different with respect to respirators and surgical masks. And at the end of the presentation, we will have some additional information from Don Berner with respect to this issue. But importantly, it's critical that you understand that if you require respirators for your employees, regardless of the kind of employer you are, if you're going to require a respirator, then you need to follow the regulations provided here. And that is, you have to have a respiratory protection program, follow fit testing and medical screening procedures, and train your employees on the proper use of the respirator so that it works. If you are only permitting respirators, you tell your employees, if you want to wear one, you're welcome to do so, but we're not requiring it. Then we need to provide the notice found in the regulation identified here in Appendix D. All right, let's talk about the Americans with Disabilities Act real briefly. The ADA still exists, it's still in effect, and it's important that we not forget that there are circumstances, even in the midst of this crisis, where we need to recognize that an employee with a disability is entitled to a reasonable accommodation if we can provide that without causing an undue burden to the workplace. The COVID-19 outbreak has caused some complications to folks who have disabilities. If you have employees who have compromised immune systems, if you have employees who otherwise are at higher risk of serious illness if they were to contract COVID-19, we need to do everything we can reasonably under the law to accommodate those employees, so long as we're not creating an undue hardship for ourselves as the employer. Think first about telework, as I mentioned before. Beyond that, though, if you have an employee who needs to not be in the workplace due to the risks involved, a temporary removal from the work rotation may be a reasonable accommodation under the ADA. The direct threat rules under the ADA allow us to send an employee home if they pose a direct threat to the workplace. Under the circumstances right now, signs of COVID-19 in an employee are considered to be a direct threat situation where we would have the right under the ADA to send an employee home who finds himself in that situation. Okay, let's talk about employee separations. There are many employers, unfortunately, who are in situations where they're trying to make difficult decisions with respect to how much of their workforce they keep on, whether they consider furloughs or layoffs or otherwise separate with employees. One consideration that you might look at before you let large groups go is to look at the shared work programs that are available in many states. Both Kansas and Missouri have similar programs under their unemployment rules, and many other states do as well. Under those shared work programs, you can reduce your employees' hours and pay by somewhere between 20 and 40%, and then the employees can also collect unemployment for that lost portion of their work time while still being able to keep everyone employed. Certainly encourage any laid off or furloughed employees to request unemployment right away. In Kansas, the waiting period has been waived, and so employees are eligible to receive unemployment as quickly as their application has processed. There's not any time in between the application process and their ability to begin to receive benefits. Next, if you are considering providing severance agreements in exchange for release to groups of employees who we need to let go, there's specific rules that we need to comply with if you're going to attempt to release age discrimination claims. The Older Workers Benefits Protection Act requires certain waiting periods, requires certain language, and requires certain disclosures to the employee to make that age discrimination release stick. Work with counsel, work with your attorney or contact us if you're thinking about doing a group separation package, because if those are not structured properly, you may end up providing the severance payments and not having those claims properly waived. A couple of comments with respect to the Worker Adjustment and Retraining Notification Act. This is the WARN Act. WARN applies to employers that have 100 or more employees, and if that workplace experiences a plant closure or a mass layoff that impacts the minimum number of employees provided here on the slide, then there are legal obligations to provide written notice to employees at least 60 days before that employment loss. Now, there are some exceptions that apply in certain circumstances, but again, this is a situation where it's really important to work with counsel who has worked in this area before, because the requirements are very specific, and if we don't comply with those notice requirements appropriately, there can be penalties to the employer for doing so. The most important exception, and the exception that we've received lots of questions on, is there's an exclusion under WARN that reduces the notice period required if an employer is needing to order a plant closing or a mass layoff in less than 60 days due to unforeseeable business circumstances. If that applies, and we think it likely will apply or may apply to many employers if their work reductions are due exclusively to COVID, it does not make WARN inapplicable. It just simply reduces the requisite notice period for those impacted employees. Again, lots of technical provisions in WARN, and so we encourage you to contact counsel before jumping into a WARN situation. All right, at this point, I'm going to turn things over to Sarah Stula and the Foulston panel for our question and answer session. For those who may have joined the conference late, we're going to focus for the next 30 minutes or so on questions of general applicability to our participants. We've received dozens of questions ahead of time, and we have received many questions throughout the presentation as well. Please feel free to continue to send those via the chat function in the webinar. Sarah?
Alrighty, thank you, Tara. I'd like to give this first question to Don Berner. Our first question is, employers are asking whether N95 respirators are needed for their employees. Can you address that concern from a healthcare provider standpoint and from a non-healthcare provider standpoint?
So I'll start off with a general thought on respirators. And so to the extent that an employer is required to use respiratory protection with an N95 or higher, for example, and that's going to typically be someone in the healthcare arena that's exposed to a hazardous substance or exposure, you want to make sure that you're following the respiratory protection program requirements under the OSHA rules. I think the trickier part of the N95 respirator issue is how is that going to apply in the context of employers that maybe don't traditionally use face protection or a mask of that type. What you run into in that situation is, to the extent that you're requiring its use, and this would be generally a non-healthcare employer, you want to make sure that you have a respiratory protection program in place. And my guess is most employers who don't typically use these respirators don't have one, and those requirements have some pretty substantial hurdles to jump over, including fit testing and medical evaluations. So you don't want to just have a knee-jerk reaction to say everybody in my workplace should be wearing a mask to the extent that you're able to find them. The other thing to be careful of for an employer that doesn't require the use of a mask is if we allow someone to voluntarily put one on, there are some implications under the respiratory protection standards as well, and we've got some disclosures to provide as part of an appendix to that standard. So just allowing your employee to wear an N95 mask can drag you into the respiratory protection program regulations. So the other thing I'm going to tack onto this as we start to tackle these questions is to keep in mind that we're getting a lot of questions related to the new FMLA provisions under the Families First Act, and any answers that we give you are based on how it interacts with the existing FMLA and what we think it means. Just keep in mind the DOL is going to issue those regulations at some point here in the next, hopefully, week before their deadline of April 2nd to help address some of these questions, and it may change the answers here, so do stay tuned for that. When the time comes, we'll issue some more information with respect to those regulations when they come out.
Thanks, Dawn. Next question is, well, actually a lot of questions on the topic of how these tax credits work for the emergency leave types. And so, Jason, I want to ask you if you could generally explain how these tax credits are going to work, and especially in regards to public entities.
Hey, Sarah, this is Don Berner. I'm going to interject one more thing before I let Jason answer the question.
Sure.
That we've had a lot of comments about slides being available from the presentation, and we will make the slides available, and there will also be a recording of this presentation available as well at some point later today.
Okay, this is Jason. I'll try to kind of dive into this tax credit topic without getting too far into the weeds. So the way the subsidy works for employers that are eligible for the subsidy is that they are to be reimbursed out of the Social Security taxes that the employer would otherwise be paying on behalf of wages that it pays to all of its employees for all reasons. So, for example, if I have paid or I'm obligated to pay $8,000 in Social Security taxes and I've paid out $5,000 in wages, I can sort of claim an offset against my Social Security taxes for that $5,000 of wages that I paid. That's the super high level. Now, a couple of nuances that are, I think, helpful to understand. One, because this is a credit against payroll taxes, if you're an employer that doesn't pay income taxes, so you're a tax exempt organization, for example, you'll still be able to claim this credit because you're still paying payroll taxes on the wages that you pay to your employees. So you should be in good shape there. Governmental employers, public agencies under the law are expressly excluded from eligibility for the tax credit. It's not entirely clear why that decision was made, but it's clear in the legislation that the public employers, including the state, political subdivisions of the state, which would be counties, cities, school districts, and then agencies or instrumentalities of the state or its political subdivisions. So that may include, various agencies or, certain governmental hospitals and other similar organizations. I'll just say there's always kind of a tough question about whether an employer in some cases is a governmental agency or not. There's lots of organizations that are sort of quasi-governmental or receive funding, and we'll just have to sort of wrestle through those situations on a case-by-case basis. But public agencies are not, however that ends up being defined, are not eligible for the tax credit. Last thing I'll mention on the tax credit, the IRS came out with some soft guidance late last week where they said we're essentially going to let employers begin self-help claiming this tax credit immediately. So if you're an employer and you owe employment taxes, including FICA taxes or income taxes that you withhold from your employees' pay, you have to deposit those with the IRS on a regular basis, and how frequently you deposit depends on how much tax you're depositing. But the IRS has said you're going to be able to withhold from your deposit the amount of the credit that you are owed for wages qualifying wages that you paid under one of these two wage mandates, so that you can immediately sort of recoup. You don't have to go file a claim and get a check back from the government. You can just offset against those tax deposits. And again, that's against the taxes you would otherwise be depositing for all employees, not just the employees that are affected by this, by the paid leave mandate. To the extent your offset there is not sufficient to fully recoup what you've paid out in wages, then there'll be apparently an expedited process to request a refund. Again, the IRS is still developing the guidance, but they've said there'll be a form and a process, and that you should be receiving a refund in as quickly as 2 weeks. So we'll see how that plays out. We're supposed to get more guidance on that this week, but that's roughly how the process is going to work.
Next question is, some employees get paid based on commission, and these emergency leaves tend to talk about full-time and part-time employees and how they get paid. How will employees who are paid by commission be paid under these emergency leaves? And I'm going to give that question to Forrest.
The statute talks about the pay provisions in terms of regular rate, which is a term that comes out of the Fair Labor Standards Act. And for those of you that have commissioned employees, you hopefully have been working with that for a while, that you have to build a component of the employee's commission into a regular rate to determine if they're entitled to overtime or not. So the statute itself doesn't identify the time frame when you would determine the regular rate. It doesn't make any sense that it would be determined during the time that the employee is using the leave, because then they're not making commissions and nothing would be included. So I think the best guess, pending further guidance from the regs, is that you'd want to look at a representative time frame preceding when the employee asked for leave and identify what their average wages, so to speak, would be, using that traditional FLSA regular rate calculation, and have that be the amount that they would be entitled to get while they're on leave.
The next question's for Tara. What about people who have had to stay home prior to April 2nd? Is that gonna count towards leave? Because the April 2022 date of when this should start will have already passed. What do you say about that, Tara?
We're waiting for guidance from the Department of Labor to get a confirmed answer on that question. But as of today, what we believe to be the case is that leave that we have provided employees before April 2nd will likely not count towards the federal paid leave requirements, and accordingly, there won't be a reimbursement to the employer for paid leave that's paid prior to April 2nd. Again, it's possible the Department of Labor will come in and make that effective date earlier than April 2nd and allow us to qualify. But as of this time, our recommendation to you all is that time that we are providing employees off of work right now before April 2nd will not qualify for the reimbursement from the government, and it does not satisfy our obligation to provide the new forms of federal paid leave.
The next question is for Jason. How do I count employees in subsidiaries or affiliated companies? And the root question seems to be, how are employees counted under the Act?
All right, well, unfortunately, there's no real easy answer to this question, and we're certainly going to be looking to the guidance to hopefully provide some clarity. In the employee benefits world, where some of you may be familiar, we aggregate all employees of controlled or affiliated organizations. So if you have 80% or more, ownership or common control, everybody in all those organizations gets added up and counted as a part of a single employer. The standards, the aggregation standards for these two new types of paid leave are different than those employee benefit plan rules. They are the standards under the FMLA and perhaps under the FLSA, which look at more of a sort of an integration or joint employer type status. And frankly, those rules were written with a little different purpose in mind, and so they don't fit as neatly into an analysis like we're looking at here, where you're trying to decide whether you've got enough employees that you are or are not above or below that 500 employee threshold. So we really are going to need some guidance to help flesh out some of the nuances. But as a general proposition, but at least my thought is, if you've got a group of related entities that more or less operate as a common enterprise, you've got common management, you've got common policies, you manage the workforce on a common basis, and you've got that common ownership or control. Those organizations are likely to be aggregated, and so all of those employees are going to count toward the 500 employee limit or threshold, even though they may be employed by separate entities, separate corporations, parent and subsidiary entities, or affiliated entities. But where exactly how we draw the line on when you aggregate and when you don't, again, is a little bit unclear. It seems to me, and we run into this in the employee benefits area all the time, that you shouldn't really be able to structure your way in and out of these rules just by cutting up your organization into a bunch of subsidiaries and dropping your employees down into them so that each one of those subs is below 500, or if you really wanted to be above 500, to sort of disband all of your separate lines of business and pull everybody together and get above. So that's what leads me to believe that this may be a little bit more like what we deal with in the benefits area. In terms of, if you've got a common control and integrated enterprise, you're likely to be aggregated. But again, we'll have to wait and see. Now, a couple of maybe nuances related to how you count or aggregate employees. There are a couple of exceptions, or at least potential exceptions, for employers that are below, that have fewer than 50 employees. Now, that I want to clarify that there really isn't a standing exception, but there is the authority for the Department of Labor to exempt smaller employers with fewer than 50 employees if compliance with the law would jeopardize their ability to continue as a going concern. And so one of the questions is, if I've got a subsidiary with fewer than 50 employees, does that qualify as a small employer that might be eligible for this exemption? And again, while we don't know exactly, my personal thinking is that if that subsidiary with fewer than 50 employees would, under these general principles we've been talking about, be aggregated with the employees of other affiliated entities, and on a collective basis they would have more than 50, that's probably not going to count as a small employer or an employer that's eligible for the exemption. So again, dropping all of your groups into subsidiary organizations of less than 50 employees is probably not going to be an angle to allow you to claim an exemption from the mandate, but we'll have to see if the guidance tells us any more about that when we see it. Another question that comes up in this area that's sort of related is, when do I measure, when and how often do I measure whether I'm above or below 500 employees? Even if you assume, we know which entities are going to be aggregated together, what if I'm losing employees or I'm gaining employees, and I'm close to that threshold? The law is not specific on that, and in fact, it muddies the water a little bit, particularly as it relates to the FMLA provision, which for other FMLA purposes, to determine whether you're above or below 50 in those contexts, it has kind of a look back and averaging type test. You look at 20 non-consecutive calendar weeks in the current and prior calendar year, I believe. 20 non-consecutive weeks in the current or prior calendar year. That rule apparently has been overridden as it relates to this particular category of paid leave. And the question is just whether you have 500 or more or less than 500 employees. If you think about it hard enough, you could talk yourself into the non-practical conclusion that you might actually have to measure this on a day-by-day basis. If on the day an employee goes out on an otherwise qualifying leave, I'm below 500, then it's subject to the rule, and if we're above 500 on that day, it's not. That seems impractical to me, and my guess is that the guidance will give us some more flexibility on that, or at least some conventions that allow for a little bit more practical treatment. But if you're close to the line, there is going to be a question about when you go above or below, and we're just going to have to stay tuned for a little bit more guidance on how that's really going to work.
The next question is for Dawn. Can the emergency FMLA leave be taken intermittently?
So at this point, without further guidance from the DOL regulations, the leave, if you look at how it's pieced together with the existing statute, will not be able to be taken intermittently. I'm sure that's something that the DOL will address in their regulations.
All right, the next question is for Tara. When summer comes and the schools are closed because of summer break, not COVID-19, at that point, will people with kids out of school still qualify for emergency FMLA?
It's not entirely clear, but I think the answer is likely to be yes. The way the statute reads is that employees are eligible for that new form of FMLA if the employer is unable to work due to a need for leave to care for the son or daughter, if the employee's school or place of care has closed or the childcare provider is unavailable. So it doesn't say this ends when summer break starts. And the practical reality is, many parents have other childcare situations arranged for their kids for summer that may also not work the same way that they would have worked before. And so if that childcare is not available, we anticipate that the employer would still need to provide that FMLA. The employee would be qualified for it even during the summer.
Next question is, do you have any advice on how to handle the lockdowns for employees that need to be able to work? And by lockdowns, I think this means these stay-at-home orders. I'll give this question to Dawn.
So one of the common questions that we see a lot of is, how do I help my employees that have to come to work? if they're going to be traveling back and forth and maybe subject to a law enforcement stoppage. I think one of the common ways that I'm seeing that handled is for employers to provide a letter to the employees that they're part of one of those essential functions and that this employee is required to work, and give one of those to each of your employees so they have something to hopefully ease any concerns they may run into with traveling back and forth to work.
I'll take the next question. It says, if an employee can telework, can we ask them to telework instead of using the new federal child care leave? Well, the new Federal Child Care Leave Act actually says only if an employee is unable to work or telework due to a need for leave to care for the son or daughter. And so that suggests that if the employee is able to telework from home when their kids are out of school and are at home, then you can do that. The next question, can an employee decline telework and take the paid leave time instead? It's kind of an add-on question to the one before. Forrest, can you take that one?
Sure, Sarah. I think our read of this right now is if you view it sort of akin in the FMLA, in the previous FMLA world to light duty, an employer can't mandate that an employee take light duty. You can make it available. If they choose to do it, then they're not taking FMLA. But if they have a right to take FMLA if they're otherwise qualified. And I think from an FMLA standpoint, from the revised FMLA provisions under the new law, we can't force it, and the new paid sick leave law doesn't even incorporate telework into the requirements. So no, I think the upshot is in either case, we could make that available as an alternative, but we could not mandate it on the employee.
The next question is whether if an employee is afraid of exposure and stays home, does that qualify for some type of emergency leave? And what options does an employer have when employees are afraid to come into work? I'll give that question to Tara.
So an employee who chooses not to come to work because they're concerned about exposure, but who is otherwise not subject to an isolation order, not subject to a direction from their healthcare provider to stay home, would not qualify for paid sick leave under the new laws. Again, the list of those first three categories for paid sick leave that apply to the employee themselves only qualifies employees who are subject to an isolation order or who are experiencing symptoms or who have been advised by a healthcare provider to self-quarantine. An employee who chooses on their own due to their discomfort maybe going into the workplace, if they choose not to come into the workplace from that perspective, they're not eligible for paid sick leave under the new law. Now that said, the practical advice we're giving employers is do what you can to be flexible with people right now as much as possible. If you have an employee who doesn't feel safe or doesn't feel comfortable coming in and you can operate your business without them, we encourage you to allow that employee to use PTO if they have it, or to put them on unpaid leave, but they're not going to qualify for the new forms of paid leave.
The next question is for Forrest. How do paid time off rules interact with leaves for salaried workers?
Not counting the paid sick leave rules that we've been talking about, just your employer's existing paid time off rules are not impacted by this. And employees would still have, including our salaried employees, they would still have a right to take their paid leave, and we would still have a right to mandate that employees take paid leave. And if that means amending our policy prospectively to allow that because circumstances have changed, that's certainly something that we could do. We'd want to give employees notice of the change, and it's going to be effective at some point after the notice. We're not going to make it retroactive, but I don't see any issues there. Now, kind of a follow-on to that, remember with our exempt employees, we've got the salary basis rules to account for, and there's those salary basis requirements deal with what the employee gets in terms of pay. So if we're mandating someone use paid leave in place of salary, that still counts towards our satisfying the salary basis requirements. And kind of lastly, another sort of tag along to that, we've seen some questions that have come in about what if our salaried employees are going to be working a reduced schedule? What flexibility do we have to reduce their pay? The salary basis rules don't prohibit prospective changes in salary that are intended to be at least indefinite or for a significant period of time. You'd want that change to be prospective only. So again, we're not changing anybody's pay retroactively. I would suggest that we also ought to do it to coincide with the start of a work week, so you don't have an issue where in the middle of a week you've got two different rates of pay. But if you're going to prospectively lower a salaried employee's workload and you want to make a corresponding reduction in their salary, that should be okay. Where employers run into potential difficulty with that is when over a course of time it looks like their salary is yo-yoing, and it goes down when workloads are low, and then it goes back up to normal when workloads are high. And when it's normal, they're not being paid overtime, and when it's lower, they're entitled to overtime, but they're never, as a practical matter, working it because the hours are light. When that bounce back starts occurring is when the Department of Labor may take notice and have some issues. But if you're talking about a one-time reduction followed by a one-time return to quote-unquote normal down the road, that should be fine.
The next question is for Dawn, and this is related to the WARN Act. And the question is, are separate locations aggregated for the WARN Act purposes, and how do I handle short-term layoffs that become permanent?
So a couple quick thoughts on WARN Act issues. First off, separate locations are typically not aggregated, so each facility would be a standalone location. Just beware that there are some cases where you could have them aggregated into one if you're, for example, the two locations are close by and you're sharing employees across the locations. The other thing to be mindful of with respect to the WARN Act, and we've seen some questions along this lines, what if I start off with a temporary furlough that turns into maybe a permanent layoff situation, and all you can do is the best you can do on those. If you have some reason to believe that it may become permanent, you can always issue the notice and not actually have the layoff take place, and you're fine. But if you don't issue the notice, you may be subject to some liability under the WARN Act. Finally, when you consider the WARN Act issues, just keep in mind that there are different rules with respect to partial closures, with respect to departments within an operation. So if you have more specific questions, you probably want to get some advice from your legal counsel.
Well, this is Forrest. Let me just follow on to something Don said. And remember, under WARN, you've got sort of two triggering prongs. One occurs when you have a plant closure, which is, as Don said, that's site specific. Mass layoff is the other potential WARN trigger. And a mass layoff only occurs when you don't have a plant closure. So, but if you're talking about, for instance, an employer with lots of separate sites, and none of those sites are being closed, but you're reducing your workforce at those sites, perhaps because you're only working half as many hours as you were before, then you're probably looking under the mass layoff rules instead of the plant closure rules, and then you would be potentially aggregating those employees across the sites. But if you're talking about the traditional, we're closing our branch in a particular community, our location in a particular community, that would be viewed as a single site of employment, and you'd be assessing WARN individually as to the number of employees affected at that site.
Forrest, the next question is for you. Can you comment on workplace liability for COVID-19 and how workers' comp may operate in this situation?
Sure. The underlying work comp rules aren't changing by this. So workers' compensation can apply if you've got an occupational illness that occurs through work-related exposure. Now, I think the practical difficulty in these cases is going to be, how does the employee prove that when they acquired COVID, how did they prove that it occurred as a result of their work environment? In the healthcare industry, if you've got somebody working in the ER that's handling these, it's obviously going to be a lot easier for them to make that connection than if it's someone who just happens to be working and finds out that a coworker tested positive and maybe I was exposed that way, despite the fact that they're also, you've got, perhaps they live in a community where you've got community exposure that's going on. So it certainly can be an issue. The employee still bears the burden in the work comp system of being able to demonstrate that they acquired the illness from a work-related reason. I think from a practical standpoint, the best advice to get if you get that circumstance is contact your work comp carrier and let them address that for you.
So this is Don. I'm going to temporarily moderate this. I'm going to ask Forrest to answer a follow-up question based on the salaried exempt employees and converting them to an hourly basis during this time period. What do you think, Forrest?
Sure. I think the gist of the answer would be similar to what I just mentioned in terms of a prospective reduction in salary. There's nothing wrong with converting someone from exempt to non-exempt. They're going to be entitled to overtime. Now, presumably, with the conversion, you're doing it because their hours are either going to be less or they're going to be more unpredictable. So you want the flexibility of just paying them by the hour. That's not a problem. Again, the issue's where a problem's going to arise is if you start bouncing employees back and forth between, well, you're going to be exempt today when we've got a full workload. Next week's going to be a slowdown, so you're going to be non-exempt next week. Then you're going to go back to being exempt. It's those back and forths, and that's a pretty extreme example on a week-by-week basis. But I think even if you're talking about it from a standpoint of this month you're one classification, next month you're something different, that's where problems start to arise. And there's no bright line as to how many back and forth switches are too many. There's authority that would suggest that one is not a problem. So like I said, one reduction followed by a change back to normal wouldn't be an issue. But the more you start making those switches back and forth, especially depending on the time frame when they're occurring, is when you're going to create a problem or create a risk that the individual might be viewed as non-exempt all the time because of how they're being paid.
And the last question we have time for is another tax-related question. So I'm going to give this one to Jason. How are withholdings going to be handled with these payments, these tax payments?
All right, so I'm going to sort of rephrase that and assume that we're asking about tax withholdings from these required payments of required paid leave, either the new FMLA leave or the emergency sick leave. There is a special rule that says that those payments are not subject to Social Security tax. Maybe I should back up. So when you make a payment of a wage to an employee, there are really three things, maybe four if you take state into consideration, that you withhold from that employee's wage on a regular basis. There's the federal income tax that you're required to withhold, the state income tax that you're required to withhold, and then FICA taxes, which really break down into two categories. There's a Social Security piece of the FICA tax, which as to the employee is 6.2%. The employer also pays 6.2%. And then there's a Medicare tax, 1.45% out of the employee's wage, and then 1.45% paid by the employer. And ignore for a minute the Medicare surtax that came in a few years ago with the Affordable Care Act. So you've got that array of things that you might be required to withhold from the employee's pay. I just told you the special rule that these mandated wages are not subject to Social Security tax, so you wouldn't need to withhold that 6.2% Social Security tax from the paid leave. And you also wouldn't be required to pay the employer's share, that the other 6.2%. That makes sense, by the way, because these are being refunded through a Social Security tax credit, so you don't have a kind of a loop there. The Medicare tax, however, does still apply to these wages, so that 1.45% would have to be withheld, along with the federal and state income taxes. So that's essentially what you're left with, plus whatever sort of authorized wage withholdings you might have on on file for the employee. So if they're going to continue to receive benefits, their withholdings for benefits could be taken out of the wages as well. Now, one last nuance I'll mention related to the Medicare tax. When you claim the tax credit to be reimbursed for these wages that you pay, Part of that tax credit, the wages are subject to Medicare tax, but part of the tax credit includes the ability to get a refund for the Medicare tax that the employer is required to pay on those wages. So you can actually claim a refund for the wage that the employer pays, the Medicare tax that the employer pays on that wage, and also the portion of any healthcare premiums, any health insurance premiums that are paid to the extent they're allocable to those wages. So there's a little bit more that you can claim through the tax credit than just the amount of the wage itself. And that's probably enough on taxes for now.
Jason, one of the things that I've seen pop up a few times in the questions relates to withholding from those payments that might be made under the FMLA provisions and the paid leave provisions. And how do you handle things like elective withholdings for 401k accounts and things of that nature?
Right. That's actually a good point. And I mean, the specific answer is that it sort of depends on the employer's plan and policies and how that works. But the general response is that I think these wages for those purposes are going to work like other paid time off that employees might be receiving. So for example, if your 401k plan says that all W-2 wages are eligible compensation for purposes of making 401k plan contributions, then these are going to be W-2 wages, and you'd need to be withholding on these wages the same as you would for regular pay or other paid time off, unless the employee has changed their election to ask you not to withhold on these wages. Sort of the same answer for health insurance. If the employee is going to continue to be eligible for health insurance and your policy is that you withhold health insurance premiums, the employee's share out of each sort of weeks or payroll periods wages that are paid, those wages would be subject to that withholding as well. And we could get into tricky situations like there are more amounts to be withheld from the wages than we have available wages to withhold on. So you have to kind of take those on a case-by-case basis. But as a general proposition, these elective type withholdings are going to continue to apply to these types of mandatory paid leave, the same that they would to any other type of paid leave.
Well, thank you, Jason. Thank you, Sarah, and to the remainder of our panel members as well. At this point, we need to close our presentation for today. We've referenced the anticipated Department of Labor regulations a number of times today, and we will certainly be providing additional guidance once they're issued. So keep an eye on your emails for an issue alert related to this topic. We know you may also have additional questions about your company's specific situation. We trust that you'll all understand that in light of the significant demand and our ethical responsibilities, we unfortunately cannot provide individual advice without first establishing an attorney-client relationship. We are prepared to set those relationships up quickly and be at your service, both with respect to employment law matters as well as your other legal needs. If you'd like to engage our firm, please call or email Tracy Anderson at the contact information provided on the screen. She'll conduct a quick conflicts check, gather some basic information from you, and connect you with the appropriate Foulston attorney. Thank you all very much for attending, and be well.